This chapter, titled Judicial Engagement of Dissent in the Preventive Detention Era, has been authored by Anindita Pattanayak and I, Sithara Sarangan. In this chapter, we seek to talk about how preventive detention laws came into being and how they've evolved over the years. The scope of this essay will focus on the close nexus between preventive detention laws, the stifling of dissent, and the lack of state accountability and executive overreach thereof. The first part of this essay will talk about how preventive detention laws came into being as a colonial control, as an instrument of colonial control. And post independence were continued to be retained, and new preventive detention laws were also introduced to tackle specific issues such as state insurgencies and law and order issues. We argue that although these laws came into being for specific reasons, over the years they've exhibited problematic trends and have had a severe debilitating effect on dissent and free speech. These laws have continued to operate outside a state of exception and have had a severe impact on constitutional rights such as individual rights and civil liberties over the years.
I am Anindita, a co author of the chapter titled Judicial Engagement with Dissent in the Preventive Detention Era. Preventive detention laws are framed for serious threats to safety like terrorism, but are sometimes misused as a form of executive censorship to stifle dissent. Preventive detention laws offer a convenient departure from the rigorous standards of protection assured to the accused in a fair trial. This is usually on vague grounds like public order. They were a colonial tool of repression wielded against persons critical of the colonial regime. And this fact in itself is enough for a thorough re examination of their relevance in today's society. Though courts have tried to check the misuse of preventive detention laws to stifle dissent, there is a lot more they can do within their powers. The specific issue we write about is that courts have failed to explicitly characterize the misuse of preventive detention laws as a free speech issue. The larger debate surrounding the preventive detention regime on the right to life and personal liberty has somehow obscured its chilling effect on speech and how these laws intimidate dissenters into silence. This oversight prevents these laws from taking the benefit of the positive legal developments in free speech law. The adverse effect of the misuse of vague public interest laws is recognized and tackled through cases like Shreya Singhal. Arguments adopting this line of thought have been presented to courts in preventive detention cases as well, but with little success. Our chapter highlights how the suspicion and panic that preventive detention laws thrive on have cocooned them in a state of exception, immune from sweeping developments in free speech jurisprudence.